A very big day today. The South Carolina Supreme Court heard arguments in a lawsuit challenging the state's current 6-week abortion ban.
The law was passed early last year but has been blocked since mid-August pending the decision of the state's high court in the case. News 19's Becky Buds is at the Supreme Court now with the latest.
At issue is whether the state's 6-week abortion ban, known as the fetal heartbeat law, violates the state's constitutional right to privacy.
Whether within that broad statement of policy, the right to bodily integrity, including the right to decide whether to remain pregnant, can be encompassed, and we think it clearly can be.
Attorney for Planned Parenthood South Atlantic and Greenville Women's Clinic, Julie Murray, arguing in court Wednesday that the state's constitution's right to privacy provision extends to a pregnant woman's right to have an abortion. They sued the state earlier this year to stop the fetal heartbeat law from taking effect. However, the state's attorneys argue the section on privacy in the Constitution refers to protecting citizens from electronic surveillance. They say the Constitution never explicitly says abortion, therefore a right to one doesn't exist.
It is inconceivable that a General Assembly would have in 1970 enacted a law restricting abortion except for these exceptions, and then turned around and passed a constitutional amendment for the voters to vote on that would implicitly repeal the statute they just enacted.
The hearing lasted more than 2 hours and included frequent interjections by the 5 justices who challenged the opinions of both sides. Plaintiffs say if a right to privacy does not extend to bodily autonomy, other rights could also be restricted.
There is a lot at stake here beyond abortion. What is at issue in this case is women's right to determine what to do with their own bodies and how the course of their lives will go.
South Carolina's Attorney General Alan Wilson left the court feeling confident in the state's arguments.
He stuck to the rule of law and the plenary authority of the General Assembly and the governor, the executive branch, to pass and sign laws into our legislation into law.
It's unknown how long it will take the 5 justices to make a ruling. In the meantime, abortion remains legal in South Carolina up to 20 weeks of pregnancy. Reporting in Columbia, Becky Buds, News 19 WLTX.
That hearing comes one day after the state Senate voted to stick with its own version of a more restrictive version of the existing 6-week ban instead of passing a near total abortion ban.